Hello everybody, good afternoon. Today I am going to discuss the topic temporary injunction. The temporary injunctions are mentioned in section 37 of the Specific Relief Act and Order 39 Rule 1 and 2 of the CPC. And some type of injunctions are granted under section 94 as well as section 151 of the CPC. But mainly temporary injunctions are granted under Order 39 Rule 1 and 2, and Order 39 Rule 1 A to C are the criteria, the types of relief which is mentioned. In Order 39 Rule 2, the repetition of such acts are mentioned, and accordingly, when the suit is filed in the beginning itself, the plaintiff files IA number 1 under Order 39 Rule 1 and 2, and the case when comes for first order before the court passes, the plaintiff counsel has to hear the matter, convince the court that the temporary injunction to be granted. The court grants temporary injunction in the form of ad interim injunction till next date or till appearance of the defendant, and it is a discretionary remedy for the court either to grant or not to grant. So once if the ad interim injunction is granted, the plaintiff has to comply the same as per Order 39 Rule 3, and he has to issue the copy of plaint and IA through register post and file a compliance affidavit with postal receipt that same is complied, and accordingly when once the compliance is made, the certified copy of the temporary injunction, that is certified copy of order sheet, is supplied to the plaintiff counsel. Then at the same time the plaintiff counsel has to pay the necessary process fee for issuing the issuance of summons, temporary injunction order or order on this application. So this process once is paid to the court, then summons as well as other that is the IA as well as a temporary injunction order issued to the defendant. Then once the defendant appears in the case, he may file objections, and thereafter both the parties will hear, and before that if defendant intends, he can file application under Order 39 Rule 4, and both the IAs will be heard by both the side, and court will decide the matter. If the court convinces that injunction is to be continued, the court will allow IA number 1 and reject IA number 2 filed by the defendant under Order 39 Rule 4. If such an order passed after hearing both the sides, that order is appealable. Accordingly, as per, if the parties who agreed, if the temporary injunction is granted, then the aggrieved party can approach, that is the defendant can approach the appellate court by filing miscellaneous appeal. Before that, when the plaintiff has been granted the temporary injunction by allowing the IA number 1, then the plaintiff counsel files a caveat petition before the appellate court. And once if the defendant files miscellaneous appeal under Order 43 Rule 1 before the appellate court, both are attached together, and thereafter the matter is heard. But in the injunction before this, temporary injunction before this lower court, the plaintiff, it is granted in favor of the plaintiff to protect the suit property intact for the trial, and if the protection is not given, there are all the chances that there will be multifarious suits and plaintiff will be dispossessed, etc. Under various type of circumstances, the plaintiff sought the relief of this preventive nature before the court. So here usually the temporary injunction not to alienate is granted till further orders. The category of sometimes ad interim injunction is granted till next date, and same is continued up till order pass. Sometimes it is granted till appearance of the defendant, but sometimes the nature of relief, that is not to alienate, is granted till disposal of the suit, etc. So here the temporary injunction are very important for the purpose of the for the purpose of the continuance of the suit. If the suit is continued and this for the purpose of continuance of suit, if suit property is intact, then only this suit can be continued, etc. So hence I am concluding my brief lecture on this temporary injunction.